No, that's all right.
I'm
Please listen.
suffering past
I'm
2 years.
I'm
I have
not
not seen my daughter.
Listen to
It
what
is my main worry.
you are not willing to listen to the
Yes,
court.
sure. No, yeah.
Anybody who comes to the court comes because he or she is suffering. So that may be a breaking news for you. For us, it goes on. Okay, so fact that you are suffering is not a big news, but we do understand that these are very sensitive matters. Yes.
This is with regard to the custody of the child, wherein the family courts directed with regard to the arrangement to be made between both the parties. The problem is they are not complying with it and shifting the burden to the minor girl that she is refusing it. Can they do so, my lord? In between, my lord, as per the
That's all right, but you have got a proposal.
that's been worked out. I am working on it, my lord. He has given the father. Has been there. He has given some of the suggestions, my lord, and that suggestion I can put it forward, my lord. But more
There
have
is
to
the
be
order
worked out.
2411.
Yes, yes, my lord. It would take time a little bit, my lord, because some roadmap has to be there, my lord, which is concrete, my lord.
All right, you see, these are very sticky areas. We are trying to find a way forward.
Yes.
Otherwise, we'll go into the legal issues and either allow or dismiss the contempt case.
That can be
But
done.
we don't want to do that because if the
Yes,
contempt case is dismissed, that's the end of the road for your client
Yes.
for all times to come,
Yes.
unless you get relief from Supreme Court.
Yes.
So before that, since it is a
We
child,
have been before the court for the third time before this honorable court. And each and every time, my lord, some way or the other, my lord, it's been pushed back to the family court. And family court has been passing order.
Mr. Bhuya, please understand. Your client's stand is okay. We understand. Your client think he has been wrong. They would think they have been wrong. This will go on.
Go on.
And if necessary, we can give an order on that.
Yes.
But the court felt that it is always better to see if we can find
Absolutely.
a way out.
Absolutely.
Because ultimately, as long as both parties are not happy, the fight will go on.
Yes.
And the child's future is finished.
Absolutely.
One order is passed this way, that way, the other side will go up.
Absolutely.
Again, it will be stayed. Again,
Huh?
another 2 years, 3 years
Minor.
will go on. And then even eventually one of the party will be unhappy.
It's been playing with the life of the minor.
One of the party will always be
Yes.
unhappy.
Yes.
And you have
I'm
seen,
the greatest loser. I'm the father.
recently you have seen to what extent things can go.
Minor.
In the media, we know.
Yes.
So you tell us, you tell me that no, we don't want any solution. Hear it on merit.
We want solutions, my lord. We
Then-
want to respect the court's order. That's all, my lord.
All right.
That's all. Nothing else.
Because he has raised, Mr. Chaudhary has raised a technical plea about the maintainability of.
Yes, my lord. I will try to satisfy this honorable court.
You want the matter to be heard today on merit?
I leave it to your lordship discussion, my
No,
lord.
no, you can't do that.
My lord,
We'll
that
record.
roadmap, my lord.
Whatever you say, we'll
What I
record.
am on, my
My
lord.
lord, can I suggest one thing? My learned friend is playing the victim card. We do not know who is the victim, my lord. Let the matter be referred to mediation, my lord. Let mediator get an feel of the whole issue, my lord.
Let it be, my
Yes, my learned friend, stop crying this, my lord, victim card. We also know so many.
No, you ask him, Mr. Bhuya, you ask your
Yes.
client. Don't push him into anything.
You want to go for mediations?
I think, my lord, the mediator, if he properly handles the issue, let us not be involved. Lordship will get a clear picture of the issue. In any case, my lord, this otherwise on merit, this contempt petition is not maintainable. That I can satisfy your lordships. Even this petition is not maintainable in this present law. But having regard to the welfare of the child, since your lordship is thinking otherwise, we have no objection.
Listen, he's the.
Yes, he's the father, man. Yes,
Please come forward.
He wants to speak.
What is your name?
I'm Parthaprati Mahanta, sir. Yeah, I based in Bangalore.
No, that's all right.
I'm
Please listen.
suffering past 2 years. I have not seen my daughter.
Listen to.
It is my main worry.
You are not willing to listen to the court.
Yes, sure. No, yeah.
Anybody who comes to the court comes because he or she is suffering. So that may be a breaking news for you. For us, it goes on. Okay, so fact that you are suffering is not a big news, but we do understand that these are very sensitive matters where a child's future, father wants to see, the mother doesn't want. This dispute is created at home, right? And there is a way of doing it to pass a judicial order. That order, if we decide it technically, technical legal issues, there no emotion is involved. You may succeed or your petition may be dismissed also. If it is dismissed, it is over for you for all times to come. If you succeed, they may go higher up and there may be further litigation. In this process, both of you will not be in peace and the child's future will be ruined.
Yes.
That is why we are thinking a little out of the box. Even if it takes another 2-3 months, we are trying to look at a lasting solution. There are ways and means of arriving at that. We have technically qualified people who are trained to handle this, which is called a mediation. Mediation, no lawyer is present. You and the other side will come and the person will speak and find out what is the key problem and how the amicable solution can be worked out. That is done in the absence of lawyers. Your lawyer can also come. Your other side's lawyer also cannot come. This is already
Let lawyers be not there, man.
will not be there. So
Neither
would you
be
like
not.
to explore that? Supposing both of you agree to, because there the technicalities of law will not be applicable. Would you be interested? If you are interested,
Honor,
we can send it.
Your Honor, this happened several times in family court.
No. We are talking about High Court mediation. Don't be under pressure. You
And,
take your.
I just want to place one word. Is purely a criminal conspiracy against my daughter.
All right. So that argument we'll hear from your
Yeah.
lawyer, not from you.
And
You can't
totally
argue on
damaged
law.
her
Your lawyer is there.
mind. So I am not sure whether counseling or mediation will help or give a solution.
That no.
Well, my advocate is suggesting now, so we'll go ahead.
No. Please, you don't be under any pressure. On the mediation, if you want to ask any question, you can put it. But what is the legal issue, whether there is confusion, that you cannot argue. For that, your lawyer is there. We are asking you that do you think you can take another chance, another 60 days, where both sides will appear before a technically trained mediator who is at the High Court level. And that mediator will try to find out a solution which is amicable, away from the technicalities. If it doesn't succeed, then we decide the case on merit. If it
Right.
succeeds,
Yeah.
then this is closed.
Sure.
Would you like to explore that?
Yes.
That would mean another 60 days to 90
Or
days.
maybe little more also. my
Yes, 60 to 90 days minimum. But a decision this way or that way is not likely to be accepted by either side. So it is a matter of few years. Even if you win, it's a matter of few years. Would you like to explore that?
Sure, sir. Yes.
Absolutely clear in mind.
Yes.
The court is not imposing it on you. You have to decide.
We'll
You have to
see.
choose.
I want to explore.
You want to explore?
Yeah.
We
In
take
fact,
it as your
I
client's-
suggested.
Yes.
Well, in fact, I think my colleague will convey it to them.
So then we'll record it and we'll ask the mediator to expedite.
Yes, within initially, Lordship will put a 60 days time limit,
Yes.
maximum another extension of 30 days, max maybe.
All right. You take down. Mr. A.K.
okay.
Bhuya, learned counsel, is present for the petitioner. Mr. K.N. Chaudhary, learned senior counsel, is RM Property is present for the sole respondent. After hearing the parties at some length and having considered the order dated 24/11/2023, based on which certain suggestions have been made by the learned counsel for both the sides, this court is convinced that this is a fit case where an attempt should be made to explore the possibilities of a negotiated settlement of the core dispute with the help of a trained mediator. Mr. A.K. Bhuya, as well as Mr. Partha Pratim Mahanta, the petitioner, is present in person and have conveyed their willingness to participate in the mediation. Mr. K.N. Chaudhary, learned senior counsel, also submits that his client will be willing to participate in the mediation process if an order is passed on that behalf by this court. First up. However, learned counsel for both the sides have agreed that during the process of mediation, neither party be allowed to be represented by a lawyer. Full stop. Taking note of the submission of both the sides, this matter is hereby referred to the Gauhati High Court Mediation Center. The Secretary / Coordinator of the Gauhati High Court Mediation Center would take expeditious steps to engage a trained mediator so as to um, so as to so as to mediate this case. A report from the mediator be placed within 60 days from the date on which the mediator is appointed, since both parties have assured cooperation of their respective clients in the mediation process. Registry would take all necessary steps to ensure that there is no unnecessary delay in.
Look, we both can appear on a particular date to be fixed by your lordship.
Will cooperate with the mediation process and as agreed to by them. Both the sides are directed to appear before the mediator on 12th of February 2000. 12th of February is fine. 2024. A copy of this order is sent to the secretary to coordinator of the Gauhati High Court Mediation Center and be also furnished to learned counsel for both the sides.
Deeply.
Deeply.